Good morning.
Mr. Stern.
Good morning, Your Honors. This case arises out of two sets of disciplinary actions taken or threatened by the Department of Industrial Accidents against attorneys under the authority given to the senior judge by Chapter 152, Section 7C, to deny or suspend for cause the right of any person to practice or appear before the department. In one arising out of Ferrera's case, petitioners Ellis and Berg were suspended by the senior judge. In the other, Packard's case, Ellis, Berg, and Benoit were referred to the senior judge for discipline, and that case is now pending.
Would you say this is okay if they weren't lawyers? In other words, there may be other practitioners that sort of regularly appear. That's okay. You can discipline, you can suspend them from practice there, anything you want.
Well, I don't know if it could be for any reason, but I do think there would be authority. Obviously, it would have to be, rationally based.
Sure.
But yes, the problem here is based upon the inherent power and the exclusive jurisdiction in this court for discipline of an attorney.
Now, we have a patent bar. Well, not we do. They have a patent bar, and there are various bars, or the tax bar, who appears before IRS. And if somebody turns out not to have a clue about patents or about taxes, they can say, you're not to appear before us. Why, given the complexity of workers' comp law, can we not permit them to say, we are going to be able to determine who should appear and who should not appear before us?
Well, first of all, there's a fundamental distinction between federal agencies and agencies of the Commonwealth. There is no, the United States Supreme Court does not claim to have inherent power to control or regulate the admission generally or removal of attorneys. There is no federal BBO. On the other hand, in this court, following the recommendations of the Clark Commission, established that it would be the and really following a long line of cases back from the prior century, has held that discipline, removal, admission and removal of attorneys is an inherent power of this court, and under Rule 401, discipline is the exclusive. All attorneys in Massachusetts are subject to the exclusive discipline of this court. So that, first of all, is the fundamental distinction. Second point is what we're dealing with in this case is not some sort of a lack of there's no particular standard for knowing workers' compensation law in order to be a part of the workers' compensation bar. This is not like patent law. These attorneys were disciplined or threatened with discipline for what was claimed to be a conflict of interest.
Right, but we're not here to adjudicate that. We're here because of the reported questions which were submitted by the parties to be answered. So we don't need to determine whether or not in this particular case it was appropriate. We need to determine whether or not it is appropriate in general.
I agree, but this case actually does illustrate a problem with devolving discipline to the various agencies. Because here we have a case where the DIA views as a conflict of interest, reviews as sanctionable behavior, actions which are clearly permitted under the rules, and indeed some actions which are actually required by the rules. Making an arguable claim, making a claim for a client who has been deprived of reimbursement of expenses, those things are not in any way violations of the rules, but they were found to be violations here. And the point here is that if you fragment discipline, if you fragment the enforcement of these rules, you're going to fragment the standards as well, as has happened in this case. And not only that, but you will, If you allow the Department of Industrial Accidents to do that in this case, there will be no way that you can prevent any agency or any department of the executive or the legislature from requiring that each agency can have its own standards for admission and its own standards and its own procedures for removal. So, for example, the Secretary of Administration and Finance could say, adopt a rule that says, I have the power to remove from the bar of the Department of Administrative Law Appeals anyone who, in the words of the Board of Review in this case, has a profound misunderstanding of our dispute resolution procedure. That sort of thing, this court, for a good reason, has established a specialized agency with specialized competence, with published decisions, in an effort to make sure that discipline is consistent in every way, consistent according to substantive standards, consistent according to sanction, and that's what the BBO is all about. Furthermore, and the court has husbanded this power very closely because, as opposed to what we have here, no attorney can be suspended without, or even temporarily, without an order of one of the justices of this court, as opposed to the procedure that we're looking at under the statute where the senior judge can remove a person immediately. And the petitioner, the attorney, can't get to this court until they go through layers of administrative and judicial review.
Now, what if the agency had said, you know, we don't really need attorneys; they just get in the way. We're going to require the claimant himself or herself to be appearing without. They can have a friend, but they can't have an attorney.
Well,
could an agency do that? It may not be clever or wise, but would we say that that somehow interferes with our ability to discipline attorneys? I mean, if they can do that, why can't they do this?
Well, they don't do that, and that would present a whole other set of problems. I think that would present due process problems that are not present here. That would be like, let's say revocation of parole, which is in some cases.
But that goes to liberty, so that's a different issue.
Well, this goes to property. I think they need to follow. But that's a whole other issue, right? They do allow attorneys, and therefore we think they can't, in effect, disbar an attorney from practice on their own. What it has to do, it has to go through the BBO. Now, let me emphasize that we do not contend that an administrative judge does not have the power to deal with the case in front of him or her. If an attorney is in a clear conflict of interest, if an attorney proposes to testify on behalf of a client, if an attorney has been disruptive of the proceedings, the judge can act in that case. And that power is more than sufficient to satisfy any legitimate interest. Yes, Your Honor.
So, playing that out a little bit, so to the extent that the DIA thought that your client acted in his self-interest as opposed to the interest of the client in continuing on, whether or not that's actually true or not, but they determined that this was inappropriate to have extended the proceedings because it was really only to serve the attorney's interest. They're not going to award fees, so your view would be they could take that position and they could report that to the BBO?
That, in fact, would be erroneous in this case, but it would not necessarily offend the inherent power of this court. If, let's say, there was, we can think of clearer cases and real cases of conflict of interest, as where, for example, someone appears representing two different claimants who have conflicting interests. In that sort of a situation, an administrative judge might well say you can't represent both persons, and may well, if he thinks that the conduct was seriously in violation of the professional rules reported to the BBO. And judges do that all the time. This is exactly what happens in the Superior Court. Superior Court doesn't have the power to disbar anybody from further appearances before that court, but a judge can, and judges do report misconduct to the BBO. And that's really what we suggest is the structure that needs to apply in this situation as well.
You reference MCAD, and we certainly do have a recent case in which the issue wasn't before us, but this individual had been suspended from practice before the MCAD for certain continuing conduct. Is there any other, is that the first time the MCAD has ever done that, or is that something that happens periodically?
I don't know. I think there's another reference in another case to something like that, but I don't know.
I mean, whether
I don't know of any rule or regulation or of any statutory provision that allows it with the MCAD, and I certainly have not heard about this in any other agency of the Commonwealth, and certainly the DIA does not cite this power as existing with respect to any other agency. If I may, I would like to turn to the underlying statutory issue under the Workers' Compensation Statute, which actually led to the dispute here. And this deals with the validity of this particular regulation that had been adopted by the DIA. The 1985 revision of the Workers' Compensation Statute fundamentally changed how legal services were to be paid for. Under that statute, and since 1985, the client does not pay the attorney. The attorney may not charge the client, and the client may not pay the attorney. The client can be responsible only for out-of-pocket expenses. And instead, and the trade-off in the legislation was that if the client prevails, the attorney gets paid by the insurer, and the insurer also pays for the out-of-pocket expenses. Structurally, the workers' compensation scheme has an escalating tiers of review, and that at any point, if the client prevails, the fees and expenses are paid, and of course, as you go along these tiers, the work gets more intense, more extensive. The fees get higher, and of course, the expenses get greater as well.
Let me ask. Here, this took place after the conference and before the hearing. What took place here was the offer of settlement resolution that took place after the conference and before.
Right.
Is what happens here then that you don't get any fee because there's been no prevailing at any earlier stage?
The statute says nothing about that period.
Right. Well, I mean, here what happened, I'm presuming, maybe I'm incorrect, but that the employee did not prevail at any point before that. Was not successful
That's right.
at the conference. Was
That's
not
right.
successful before that, and so there would be no payment of any fee for any work done at any point.
That's correct.
Is that
exactly
right?
right. So that the first level is conciliation. If at that level, if the insurer agrees, and that's a mediation, so that's always by agreement and conciliation. If the insurer agrees to pay, but it's more than 21 days after the claim is initially filed, the insurer has to pay a fee.
Here, the insurer, though, was digging in its heels all along the
That's
line
right. It
until
doesn't agree to
post-conference.
pay. In this case, the insurer did not agree to pay until 11 days before the hearing.
But that means that at the conference is more than just mediation, right? I mean, isn't
The
there a
conference
hearing?
is the next. First is conciliation.
There's a determination made by somebody at a
Yes.
conference,
Yeah,
and
it's
so.
an informal.
But it was made in the favor of the insurer
That's right.
here. So
That's
it was
right.
the employee who continued on.
So right, but then the insurer offers to pay the underlying claim without any payment for attorney's fees and without any reimbursement of expenses just before the hearing.
Mm-hmm.
And now under the rule adopted by the Department of Industrial Accident, the attorney and the client get nothing at all. It doesn't matter how long this goes. This could go on for years. It could be hundreds of hours by the attorney. It could be thousands of dollars of expenses for the client. And if the insurer has passed these other tiers of review where it could have paid, and if it had agreed before, it would have had to pay a fee. Now it gets to the end and it needs to pay anything. And we suggest that's contrary to the plain language of the statute. It's certainly contrary to the purposes of the statute. And if that was correct, if the rule were really based upon the statute, we think the statute would actually be unconstitutional for similar reasons than what we were talking about a few minutes ago. Because this court has also inherent power to regulate the fees between attorneys and clients and regulate the reasonableness. And if the legislature were to say, here's a scheme in which the client is not allowed to pay the attorney, there is no way to fund this legal expense because the insurer is not required to pay for it either, we think that would come into conflict with the power of this court as well. Obviously, one does not need to get there because that's not what the statute provides. And we think even the rule could be construed in a way that we suggest in our brief that would be consistent with the statute and consistent with the Constitution.
Thank you, Mr. Stern.
Thank you.
Mr. Porter.
Good morning. Just to clarify one issue at the outset, neither attorney whose case is highlighted in this facial challenge to the statute and the regulation was referred for asserting a legitimate claim against the regulation, section 1.19, parens 3. In Ferreira's case, he was referred to the senior judge under section 7C for failing to appear at a scheduled evidentiary hearing and having done so, passing on an offer, a timely offer, made by the insurer to pay the claim in full. That was the basis for the referral. It was not because he had asserted a challenge to the regulation. And that's clear in the hearing decision in the Ferreira case in the record at page 33. The same in Packard, the other exemplar case we have here. In Packard, the referral to the senior judge occurred because the insurer had made an offer to the employees' counsel, which the employees' counsel had sat on for 5 months without conveying it to the employee. The employee then learned of the offer only at the date of the evidentiary hearing. The offer made by the insurer was to pay the full amount that the impartial medical examiner had identified as the loss of function in that particular case. So the referral was not for challenging a regulation that defines when fees are owed. The referral for misconduct in the first case was the failure to appear when they could have obtained full relief for their client. In the second case, it was for not disclosing an offer for that length of time. Again, an offer in the full amount of the impartial.
But would it really have been a full amount without the payment of expenses?
It would have been the full amount of compensation.
Well, but so why is it misconduct particularly if the client authorizes a continued challenge? Why is it misconduct to decline an offer that is in fact only as to compensation but not with respect to expenses? The employee is not being made whole.
There are other ways that they could have done it without putting their client's claim in jeopardy.
And what are those other ways?
They could have accepted the offer and then asserted a claim under Section 10, which has a very general provision that essentially is a catch-all provision allowing for claims for let's see. I'm not finding the language right in front of me, but it's for essentially any other claim arising under this chapter. So it's a kind of a catch-all provision. So
Would
the
that be
first
for
thing they
fees
could have
as
done,
well, or just costs?
excuse me?
Is that for fees as well, or just?
In this case, they could have asserted a claim for fees and for costs. Now, under the regulation, within the department, I think their claim would have been and should have been denied. But they still could have accepted the insurer's settlement in each of these cases and then later asserted a claim under Section 10 and sought fees. But because these offers were made within the terms of the regulation, 1.19, fees would not have been owed.
And how would you go about challenging that regulation?
Well, you do it that way by preserving it, and then you could bring it up on appeal. You could bring an appeal from first to the reviewing board, then to Superior Court under Chapter 30A, and then ultimately to the appeals court. Or the second way they could have done it is exactly the way they did it in the case that we're here on. They could have filed a declaratory judgment action under Chapter 231A. In either case, they could have accepted the insurer's offer, protected their employees' right to compensation. In Mr. Ferreira's case, the impartial medical examiner had ruled that, yes, he has a psychiatric injury. The insurer reconsidered its position and agreed with that, offered to pay compensation for that. But in the Ferreira case, counsel didn't appear at the hearing because they had declined to put on a case at the first scheduled hearing because they were disappointed they didn't get fees. They could have accepted the offer.
Or expenses.
Or expenses,
The
exactly.
expenses are what the client would have to pay.
Potentially, yes. And fees and expenses are.
Why do you say potentially? Isn't that the obligation of the client?
Yes, if there were expenses and
Right.
there were expenses that hadn't been
Well, they
compensated.
had an expert.
Yes. In this case, though, I should note that it's very clear in the record that there was no documentation of what the expenses were. You see in the record the frustration on the part of the administrative judge, and now I'm referring to pages 22 and 23 in the Ferreira case and 156 and 157 in the Packard case. The administrative judge was frustrated because counsel was at the hearing with an offer to fully compensate the claimant and saying that expenses were owed but had no documentation of what they were.
Isn't there a provision in the last part of the statute that we're talking about that when you get to this last stage that whenever an insurer files a complaint, et cetera, accepts a claim or prevails. Now, at that point,
Yes.
it's up to the judge to take a look at the fee and increase or decrease depending on complexity. So wouldn't that be the moment, an appropriate moment, which a judge could say, you know, you really sat on this and you didn't need to wait, and so we're going to give you nothing, or we're going to give you $500 because, well, yes, you were here until that point and you shouldn't get zero, which is, that's the outcome, right? Zero for all the work that's been done. You shouldn't get zero. So let's talk about it. But that's right in the statute.
The outcome is zero under the regulation, and what the regulation does is it defines when the claimant prevails at the hearing stage. Mm-hmm. And it does so in a way that's perfectly consistent with Section 13A5 of Chapter 152. As we see from that section, it has two parts. Part number one is if it's kind of stated in the reverse. It says that the insurer owes fees if it makes essentially a belated offer of settlement, a full offer of settlement. Mm-hmm. But if that's not accepted and the employee then goes on to hearing but does not recover more than the offer of settlement, under the regulation, the employee has not prevailed. And that's certainly consistent both with the structure of 13A5 and generally with the structure of Section 13A, which describes how fees are determined at various stages in the proceedings.
Right, but you have that somewhat peculiar feature that if it resolves itself at conciliation, where the attorney has not invested much time, the attorney gets $700 plus expenses. But if it doesn't resolve then, perhaps because the insurer is not willing to pay, And then you go to conference. I guess if the employee wins a conference, he would get the $1,000?
Yes, at each stage, the fee is owed
Okay.
when ordered. Yes.
So he would win the $1,000 if he won at conference. Here he
Plus
loses.
necessary expenses.
Okay, but here he loses at conference. So then he finally does reach a settlement, and if he had reached a conciliation, he gets paid, but now he gets paid nothing.
I think, Your Honor, that even if it appears harsh, it reflects kind of the dual nature of the interests advanced in the Act. They're both to provide for representation and attorney's fees for claimants, but also, and we see this in Green's case, cited in our brief, another purpose of the Act is to discourage needless litigation.
I think this encourages insurers to continue through to the third phase and then make an offer, because it's short money if they lose in the first go-round, and it's bigger money if they lose at the end. And then all they have to do is make an offer. And that's it. Nobody gets paid anything.
We would submit, Your Honor, that it doesn't encourage that.
The statute seems to suggest that it doesn't really say exactly what the regulation says. The regulation seems to fill a hole that isn't specifically provided for by the statute.
Well, the regulation interprets the statute in a way to make the statute consistently discourage needless litigation. What the regulation does is it fits right within the procedure for the impartial medical examiner.
The statute itself provides for that provision that you just talked about. If there's needless litigation, and the ... in the brief is actually, and the ALJ can look at that, the hearing officer can look at that and go up or down.
But what's happened then is there's been a hearing in that case. A hearing, the Packard case is a perfect example. In Packard, the impartial medical examiner said that there was a 15% loss of function. The insurer agreed, and the claimant had no evidence of additional loss of function. So the claimant tried to not be bound by the regulation and said, well, we want to have a hearing. And they arrived, and there was nothing to adjudicate at the hearing. So a hearing was convened, precious time of the administrative judge was taken, a slot on the calendar was taken, and it was simply counsel appearing to ask for their fee. So what the regulation...
And expenses.
And expenses. And so what the regulation does is it seeks to avoid that, and it avoids that so that Section 13A5 is consistent throughout. We know that the beginning part of Section 13A that says, by negative implication, and the petitioners agree with this, that an early settlement offer made from the insurer, if accepted, results in no fees and no expenses. So if the hearing can be avoided that way, settlement is encouraged, the case is resolved, it wouldn't make sense then to see in the statute an incentive to go to the hearing when there's no issue in dispute as to compensation, just so that counsel can show up and request a fee.
But what would the insurance company have learned after the conference at which it prevailed and before the hearing that would cause it to take a different position than it took at the conference?
It's when the impartial medical report is done. It's really the key event in a workers' compensation case that precedes that far.
The IME is done in anticipation of the hearing.
Exactly. After the conference...
So if the person doesn't press to go on to a hearing, the IME won't get done.
If a party is satisfied with the conference order, the case is resolved, and there's no need for an impartial report.
So it is by going forward beyond the conference that the IME gets done.
Yes.
And it's
the
when
deposition gets done and all of that.
And that's, in a way, why this is so key. The reforms in the Act wanted to do away with the problem of dueling doctors, and so they came up with the impartial.
It isn't just a person, an IME out there who gets paid by whatever sources they get paid. Isn't there other stuff that don't you take a deposition? Isn't that how that gets before a hearing officer? You take steps? Or
there can be. It's not required. In neither of these two cases was there a deposition.
Who pays for the IME?
The appealing party.
So in this case, in order to get the IME, the employee had to incur the expense of that doctor's examination.
Presumably, yes.
And yet will not recover it under the way this regulation is structured.
That's correct.
So how does that serve the purpose?
It
of the
ser-
statutory scheme.
It serves the purpose of promptly resolving the case after the issues have been resolved. The big event in the case, again, is the determination of the impartial medical examiner. And the way the timing works is very key. That report has to be issued at least 7 days before the hearing under Section 11 or 11A. Then the insurer needs to make its offer at least 5 days before the hearing if it's going to avoid potentially paying a fee in that case. So these two cases illustrate perfectly the difference that makes. In both cases, the insurer read the report, agreed with the report, reconsidered its earlier position, decided it was not going to take up hearing time to contest the case. The employee was in agreement, and so under the rule, if the employee accepts the insurer's offer, made 6 or more days before the hearing, no fee is owed. Petitioners don't challenge that.
But this was after an IME examination in each case?
In each case, yes.
And so who paid for the IME examination in each
The
case?
appealing party pays, and
So
the employee pays.
the employee?
Yes.
So the employee has had to pursue this, had to pay these fees, and is clearly not made whole. Clearly not made whole.
The employee is not made whole to that extent, but there are, as one works their way through Section 13A, that's the section that identifies when fees are owed. The statute doesn't make an employee whole in each case that they win benefits. An employee is paid fees if the insurer does not settle and the employee later prevails. So, for example, there's an earlier provision.
So if the IME comes out with a conclusion different from what the insurer was prepared to pay to settle, then that's not a prevail. Then he hasn't prevailed.
If the
Because if the IME comes out with a conclusion different from the position the insurance company has taken, and the result of that is that the insurance company now pays everything the IME says,
Yes.
Why isn't that prevailing, and why shouldn't costs be awarded to the injured employee?
It's because the statute as structured identifies the
Prevailing
claimant
moments, and
as
that's not a prevailing moment.
Exactly, as prevailing when there's a contest.
Okay, can I?
And the
Obviously,
employee
there's been a
prevails in the
contest because otherwise the insurer would pay. But let me go back to the first question, which is bothering me. I wasn't bothered so much at first when I read through the briefs, but the more I thought about it, the more I am bothered with the notion that executive department agencies can set their own codes of conduct for lawyers and conduct essentially their own disciplinary proceedings. Doesn't that really devolve into a fairly difficult situation?
I don't think this case illustrates any of that, Your Honor.
Well, let's assume in this case that the administrative judge would do what any other judge might do if they were deeply concerned about a conflict of interest that didn't seem to be handled correctly, and that the attorney was sacrificing the interests of his client for the attorney's own interest. There may be decisions to be made within the case itself, as Mr. Stern was describing, but the judge might refer to the Board of Bar Overseers and say, look, this attorney seems to be engaged in a conflict of interest that he's not paying attention to and serving himself over the interest of his client. And the BBO presumably might open an investigation, speak to the client. The client might say, no, absolutely not. Are you kidding me? I was out all of this money. I didn't want to settle. I wanted my money, and I told the lawyer, darn well, go ahead with this hearing. All right? So the BBO probably would say at that point, we don't really see a conflict of interest here. But the department might come out with a completely different conclusion. No, we don't like this because this would be inconsistent with our statutory scheme. How do we manage that kind of situation?
Well, I think we manage it in a number of ways. First of all, the referrals under Section 7C allow for process at the department, administrative review before DALA, review in the Superior Court, and obviously an opportunity to appeal. If there has been an error in the application of any
application of what? Our attorney disciplinary and ethical rules? That's
exactly.
what the DIA is applying?
Any error in the application of a regulation of the department, which of course the senior judge would be expert in, but more to the point, and as in this case, any error in the application of the rules of professional conduct could be appealed and corrected on appeal. It's not different.
How is it corrected on appeal if he's suspended the entire time?
In both of these cases, the suspension is stayed. The attorney can always request a stay. In the first case, the stay was granted at DALA. In the second case, the senior judge on his own has stayed the proceedings.
So are you conceding that the DIA is essentially disciplining lawyers for violation of our ethical rules?
The nature of the referrals in these two cases stemmed generally from that, but they were such clear and obvious problems, failing to appear at a scheduled evidentiary hearing and passing on an offer of full compensation. That case was dismissed.
Well, that sounds like a real good referral to the Board of Bar
And there is
Overseers.
nothing to stop the administrative judges from making those referrals. In fact, one of the judges in the record said he was tempted to make a referral, but he wanted to wait at least for another violation. The senior judge, though, has a better perspective, a little bit more removed. But again, what is key is that in terms of this court's exclusive disciplinary jurisdiction, it is jurisdiction under Rule 401 to discipline in the forms as identified in subsection 4, which would be disbarment or suspension from the practice of law. There is nothing in Section 7C that authorizes the senior judge to take any action affecting an attorney's license. And I think the fact that the senior judge is referring to the rules of professional conduct is a positive thing. What it is it's an acknowledgement of the primacy of those rules by the court. The superior courts are applying those rules all the time when conflicts or other issues arise in superior court cases. It's no incursion on the BBO's jurisdiction when they do that. So,
Okay, thank you.
thank you.